everyone. Welcome to the April 4th Coalition's TV show. Today is the April 6th, 2026 edition. Saturday was the anniversary of Martin Luther King's assassination in 1968. Unfortunately, I'm doing the show by myself today, so you have to bear with me. I don't usually like to do the show myself because I think it feeds into a problem with ego and everything. I like to work with other people, but bear with me. The April 4th Coalition's mission statement is, we are for workers' collective bargaining rights, and we're against tax breaks for the rich and corporations who ship our jobs overseas. We endorse all the Universal Declaration of, all of the articles of the Universal Declaration of Human Rights, but as is our custom, it is Article 23 that we emphasize. Article 23 of the Universal Declaration of Human Rights states that, number one, everyone has the right to work, to free choice of employment, to just and favorable conditions of work, and protection against unemployment. Number two, everyone, without any discrimination, has the right to equal pay for equal work. Number three, everyone who works has the right to just and favorable remuneration, ensuring for him or herself or his or her family an existence worthy of human dignity and supplemented, if necessary, by other means of social protection. And number four, everyone has the right to form and join trade unions for the protection of his or her interests. I want to thank everyone here at Northern Berkshire Community Television for making this show possible. Nicole, Steve, and Matthew, everyone, and all the work that you're doing. It allows us, it allows me to put forward some ideas that I think are valuable to share with our community. Right now, unfortunately, our nation, along with Israel, is at war with Iran. A lot of the administration officials are acting like they didn't know what was going to happen after they aggressively attacked Iran. But I want to show a video. It was on Morning Joe a few days ago with Mika introducing her dad, Zbigniew Brzezinski, who was a national security advisor for Jimmy Carter and was a very influential person in the United States foreign policy. And he was being interviewed on the Rose talk show in 2012 when asked what it would be like to attack Iran. So let's watch that video.
Multiple occasions that no one could have predicted Iran would attack its Middle Eastern neighbors if it was struck by the U.S. and Israel. Trump has said his administration was shocked by it. But back in 2012, my father, Dr. Zbigniew Brzezinski, not only predicted it, he clearly laid out the global implications of a new war in the Middle East and America's limits in controlling the outcome.
If the issue is posed in a way in which they have to, in effect, abjectly capitulate, then I think a great many of them will say no. This is a country of 80 million people. And they know that while we can inflict enormous damage on them, they can hurt us a lot. Charlie, we have been now in 2 10-year-long wars. We have wasted an enormous amount of financial wealth, not to speak of lives. Our position in the world has deteriorated. Can you imagine what the consequences would be for us if the conflict in Afghanistan expanded because of the Iranians, if Iraq was massively destabilized, if Bahrain was set on fire, if the northeastern oil fields in Saudi Arabia were attacked?
Do they have the capacity to ignite all of that?
To ignite, yes. To prevail, no. But in the meantime, the consequences, the costs, would be cumulative.
And oil prices would go through the roof.
Yes, and the global economy will be affected. So we're playing with fire here.
Yes, so he said we'd be playing with fire, and that's exactly what we're doing. It's kind of a difficult thing for me. You know, we just celebrated Easter yesterday, and we're supposed to be promoting peace throughout the world in our lives when we work with our neighbors or with our friends. And when our nation decides to attack, and it seems like there's nothing, Congress isn't standing up for or to the president, and the president is making outrageous statements of wanting to attack infrastructure and essentially commit war crimes. I try to find solace in looking back at history. So I grew up, my father was a veteran of World War II, and I studied a little bit of history, and I thought, let's take a look at, you know, what happened at the Nuremberg trials. Because at the time when the war was going on, the Germans seemed invincible. But then at the end of the war, they weren't anymore. And what happened after that? After they started a war of aggression, what happened to these powerful people? So let's take a look at what happened at Nuremberg from the History Channel. See what they have to say in this video.
It's 1945 and World War II is over. Adolf Hitler is dead. So are his top lieutenants, Heinrich Himmler and Joseph Goebbels. But dozens of high-level Nazis are still alive and in prison. What do the Allied powers do with them? They take them to court in their own backyard. The Nuremberg trials were a series of international prosecutions that decided the fates of Nazi war criminals. Why hold these trials in the German city of Nuremberg? Well, for one, unlike a lot of German towns, Nuremberg was relatively undamaged by the war. And, just as importantly, the city had been the site of several infamous Nazi rallies. Prosecuting Nazi leaders there brought a symbolic closure to the Third Reich. The trials were administered by the four principal nations of the Allied powers: the United States, Great Britain, the Soviet Union, and France. However, each of these countries had their own laws and legal system, and had to settle on a common framework of justice. They couldn't try each defendant 4 different ways. So in August of 1945, they all sat down and hammered out the London Charter of the International Military Tribunal. With the London Charter, the Allies agreed that the defendants would stand trial and be allowed to have their own defense attorneys. Instead of a single judge, there would be a tribunal, 4 judges, 1 from each Allied country. The London Charter also defined the 3 major charges each criminal would face: crimes against peace, like planning and starting a war crimes, such as killing POWs, and crimes against humanity, in other words, killing civilians, as the Nazis did during the Holocaust. The trials lasted at Nuremberg from 1945 to 1949, but the highest profile cases were brought to court between 1945 and 1946. This period was known as the trial of the major war criminals. Among the 22 Nazi leaders on trial at Nuremberg were Gestapo founder Hermann Göring, Deputy Führer Rudolf Hess, Nazi Foreign Minister Joachim von Ribbentrop, and the German architect Albert Speer. 2 additional Nazis had been indicted, but one, Labor Chief Robert Ley, killed himself before the trials. The other, weapons manufacturer Gustav Krupp von Bohlen und Halbach, was declared mentally unfit. He was senile. Starting in November of 1945, the tribunal heard testimony and reviewed evidence for 216 court sessions. The horrors and crimes of the Nazis were put on display for all the world to see. In October of 1946, the court handed down its verdicts: 12 death sentences, including those for Göring and Ribbentrop. 3 got life in prison, 4 got lengthy jail terms, and 3 were acquitted. Nothing could undo the devastation of the war. Nothing could bring back the millions of lives lost in the Holocaust and the millions more lost in battle. But the Nuremberg trials were an important step towards rebuilding an international system of justice. They established important legal precedents for future international trials, including those for Japanese war criminals and for trials decades later in Rwanda and the former Yugoslavia. The Nuremberg trials officially entered the crimes of the Third Reich into the historical record, so that there would be no doubt about what the regime had done.
Young people in large numbers came out and joined what became known as the Red Guards. These largely terroristic organizations were used to publicly humiliate, assault, and in some cases, even murder political enemies of Mao and the Communist Party.
Okay, thank you. That was an interesting synopsis of the Nuremberg trials. But what stuck out to me was it was an international trial, trying to establish international law, gave birth to a Universal Declaration of Human Rights. It also set up an international system of justice. And that's something that's very important. We have a group of people that are saying that it's America first, but they're acting, when someone says that America first, it seems like we're just going to focus on our country and try to improve the lives of all the people here living here. But it seems like they have a different idea. They have more or less an idea of an American empire, in that we are subjects of an empire, not a democracy, and that certain people are valid are treated as good citizens, and other people are seen as not welcome, not legal, and have to be expelled. And that's not what I consider an America first. But in listening to this international trials and international system of justice, in establishing, a war of aggression on another country, I think we have to do a little bit of more study of what the world thinks of crimes of aggression. So we have another video here, and it looks a little bit deeper into the Nuremberg trials, but also into what a war of aggression is.
Excellencies, distinguished delegates, ladies and gentlemen. The adoption of the Rome Statute was a hopeful historic moment near the end of a century marked by atrocities and unspeakable inhumanity. Yet, serious violations of international law continue and vast accountability gaps persist. Our abiding challenge is to realize the full potential of the International Criminal Court.
We must stay the course on this forward march of humanity. The commitment of states parties in particular to support the work of the court will be key to determining the precise trajectory of this path.
A été un tournant décisif pour la question du crime d'agression, pour avoir vu 5 États, à savoir le Chili, El Salvador, l'Islande, les Pays-Bas et l'État de Palestine ratifier les amendements du crime d'agression.
My name is Klaus Kress, and I teach criminal law and public international law in the University of Cologne. In the very early hours of today, the Assembly of States Parties took the decision to activate the International Criminal Court's jurisdiction over the crime of aggression. The international debate that preceded this decision has taken almost 100 years.
Now in his late 90s, Ben Ferencz has a broader view than most on war, peace, diplomacy, and the international legal order. In 1947, Ferencz became chief prosecutor for the United States in the Einsatzgruppen case, one of the 12 American-led Nuremberg trials held in historic Courtroom 600 for Nazi leaders suspected to have committed grave crimes, including the crime against peace.
There's no reason to glorify war. War is hell. We have to move away from the glorification that war is great and to another one that peace is great. And the UN Charter requires that. They list 10 other ways of settling disputes. Judicial settlement is one of them. Even if you lose a case, it's going to be better than war. Law, not war. Because I think law under all circumstances is better than war.
It has been a decade and a half since the International Criminal Court opened its doors in The Hague. Established by an international treaty called the Rome Statute, the ICC is the only permanent international court capable of trying individuals for genocide, crimes against humanity, and
the
war crimes
charged against him.
Klaus Kress was a member of the German delegation to Rome.
Well, the significance is that the Rome Statute, as agreed in 1998, was incomplete. One very important crime, the crime of aggression, was missing. It was left undefined. And why was that so important? The whole story of modern international criminal law started with the crime of waging wars of aggression. That was very much what the Nuremberg and the Tokyo trials was about.
Before an international tribunal holding court in the former war ministry in Tokyo come the wartime leaders of Japan to be indicted as criminals.
Originally, during the Nuremberg trials after the Second World War, the crime of aggression was called the crime against peace and dubbed the supreme international crime because it contained within it all the other crimes.
The crime of aggression is about the participation of an individual in a major illegal use of force by a state. It is about state leadership. The crime of aggression does not cover the participation of the individual low-ranking soldier in illegal military campaigns. The crime is focused towards those who actually mastermind the overall action, and that's the state leadership, the political establishment, state presidents, prime minister. It is those who are concerned by this crime.
Professor Roger Clark from the Rutgers School of Law was also in Rome in 1998 and has devoted his professional life to international criminal law.
I like to think that we're still working on a negotiation that began in Versailles in 1919 and drafting the Covenant of the League of Nations and followed through the Kellogg-Briand Pact, the Nuremberg trials, the Tokyo trials, the efforts in the International Law Commission over the years. Our failure in Rome to get agreement on a definition of the crime, but an understanding that it should nonetheless be within the jurisdiction of the court, and then of course the subsequent efforts to bring it to fruition at Kampala.
In 2010, the first review conference of the Rome Statute of the ICC took place in Kampala, Uganda. The main goal of the conference was to finally agree on a definition of the crime of aggression and the conditions under which the court could exercise its jurisdiction. Ambassador Christian Wienerwieser from Liechtenstein, then president of the Assembly of States Parties, was leading the negotiations in Kampala.
In 2010 in Kampala, we managed to find a consensus on the crime of aggression, on provisions both on definition and on exercise of jurisdiction. I think it was a success that many thought was not possible, in particular because it was a consensual agreement.
Thank you very much for listening to me at 1:20 a.m. East African Standard Time. Thank you, sir.
And with these short final words, I declare closed the review conference of the International Criminal Court.
All right.
It was decided that the amendments had to be ratified by at least 30 member states, and that the Assembly of States Parties of the ICC had to take another decision after January 2017 to activate the court's jurisdiction over the crime of aggression.
I think the Kampala consensus is, of course, a product of compromise, but I think it is a good compromise. I think for those who advocate a very strong regime, the compromise they had to make was to say that for the time being it does not apply to non-states parties. That was a big compromise, but I think that was inevitable. For the others who were rather skeptical, the big compromise was to say we gave up on the exclusive role of the Security Council in this respect.
Beyond this compromise, other controversies have persisted. Even though legitimate instances of self-defense or military action authorized by the Security Council are of course not covered by the definition, other situations are less clear. For example, just in the last 20 years, conflicts in Kosovo, Iraq and the Ukraine have generated heated arguments on what would constitute preemptive wars, humanitarian interventions, and wars of aggression.
There can be no doubt that proceedings for a crime of aggression are politically sensitive and will attract political criticism.
But in my view, the most important thing is to complete the Rome Statute, because we said in '98 the crime of aggression is one of the most serious crimes, and to have an internationally binding definition of what that crime is, because we've never had that before. So that is, in my view, the historic step.
Stefan Barriga was the principal legal advisor to the chief negotiators on the crime of aggression for Liechtenstein and is currently the deputy head of the Liechtenstein mission to the European Union in Brussels.
It took a number of states some time to then rethink the outcome of Kampala and to realize that despite the fact that each delegation did not get everything they wanted, it is still a historic compromise, and that the overall goal, the core really of this project, namely to effectively criminalize the most serious forms of the illegal use of force, that goal is actually within sight.
With 34 states parties to the ICC, Africa forms the largest regional constituency. It has outlawed the illegal use of force by one state against another in several African Union agreements. Atalia Molokome, Botswana's ambassador to Switzerland and the UN and former Attorney General, played an important role in Botswana's ratification of the Kampala Amendments.
As countries that find themselves in many respects at the bottom of the power game, as it were, I think certainly my country, as Botswana, I believe that it is important that the crime of aggression becomes legislated as part of the international criminal justice infrastructure. And I think it is for us smaller countries, the incorporation of the crime of aggression would be of great benefit, because basically we want to make sure that, power and might are not right.
Don Ferencz, Ben Ferencz's son, is the founder of the Global Institute for the Prevention of Aggression.
So my father, as you know, opened his case in Nuremberg, saying the case we present is a plea of humanity to law. That plea was answered in Nuremberg, but now, in the Rome Statute and in the amendments, we have a plea of law to humanity.
That plea was answered in New York in December 2017 at the Assembly of States Parties of the International Criminal Court.
I wish to commend the Assembly after a very serious, frank and insightful discussions for having been able to agree on new amendments to the Rome Statute, but especially for having agreed to activate the jurisdiction of the court over the crime of aggression, a true landmark in the advancement of international criminal justice and a clear signal to the world that we are moving forward and not backwards. Thank you very much. Good morning. The meeting is adjourned.
For the first time since Ben Ferencz was a young prosecutor in courtroom 600 in Nuremberg, statesmen can be prosecuted for the crime of aggression. Still, the diplomatic compromises made to activate the court's jurisdiction were significant.
In order for the court to exercise jurisdiction, also the alleged aggressor state must have ratified or accepted the amendments.
By the end of 2017, 35 out of 123 International Criminal Court member states have done so, falling short of the aspirations of full equality in the enforcement of international criminal law against aggression. But, as the ICC awaits more members and ratifications. The activation of the court's jurisdiction over the crime of aggression is another milestone in international criminal law.
It is to be hoped that over time more and more states will ratify the Kampala amendments. For those states who sat in judgment in Nuremberg, it would only mean to fully embrace their own legacy, the legacy of the creative precedent of Nuremberg.
President Trump has said on multiple.
Wow, that was very good. I mean, what stuck out to me on that video was that young prosecutor who, over time, came up with the slogan, "Law, not war." He said no matter what the situation, going to the International Criminal Court to settle differences rather than war is always a better solution. He said even if you were to lose when you went to the International Criminal Court, it's better than war, because war is just destructive to everyone. And if you look at all the history of all the religions that have grown up in all the cultures around the world, you know, they have two basic things that I think are common to all of them. One is a set of laws. They might not be the same set of laws, but they are laws. And then the other thing is that there's sacrifice, that there's a laws that you should follow, but then also that as a human being, you know, you are to look out for the other person rather than just looking out for your own interest. There's a sense of self-sacrifice, being selfless, to look out for what's better for the whole. And so, you know, law, not war, is the way that we should be going. So if we want to get power to the people and peace to the people, we have to use that concept. Go to the negotiating table, just like we do in our labor unions. We negotiate our settlement. We try to come to some sort of compromise. Nations should be doing the same. We should not be dehumanizing. We should be looking at the others with respect. That's the only way in a union contract. The first thing that you have is called mutual respect. When you have mutual respect, then you can build on a compromise and negotiate a settlement. So let's just hope that the people around the world, those that are in charge, if there are individuals that are in charge that don't have mutual respect for other human beings, they should be removed from their position, and we should put in people who can show mutual respect for all human beings and try to come to a negotiated settlement so we can live in a world in peace. So power to the people. Thank you very much.
Mistakes of the bosses we must pay for. From the cities and the farmlands to trenches full of mud. War has always been the bosses' way, sir. The Union forever defending our rights. Down with the black level workers unite. With our brothers and our sisters in many far off lands. There